My father's estate lawyer called. I was standing in the parking lot of a Canadian Tire in Barrie, holding a bag of windshield washer fluid and trying to remember if I'd eaten breakfast. That detail sounds ridiculous now, but grief does that. It makes the smallest, most ordinary moments the ones you remember. My name is Kelsey. I'm 31. I work as a forensic accountant for a mid-sized firm in Toronto, which means I spend my days looking for the money people think they've hidden. I'm good at it. I've always been good at numbers. My dad used to say I came out of the womb already checking the math. He died on a Tuesday in February. Heart attack. He was 64 years old, which everyone kept telling me was so young, as if that was supposed to make me feel something other than furious. He'd been healthy. He ran 5 kilometers every morning. He had a standing appointment for Saturday breakfast with me at a diner on Dunlop Street, and he never once canceled it in 12 years. His wife, my stepmother, Sandra, called me an hour after it happened. She didn't say, "I'm so sorry." She said, "You need to come to the hospital. There are decisions to be made." I should have paid more attention to the word decisions right then. I didn't. My parents divorced when I was 8. My dad remarried Sandra when I was 16. I never hated her. I want to be clear about that. She wasn't cruel. She was just someone my father loved, and I never fully understood why. She smiled a lot, but her eyes were always calculating something. She ran a small real estate staging business, and she was very, very good at making things look like something they weren't. My dad had a will. He'd had it for years, and I knew what was in it because he walked me through it himself at our kitchen table when I was 26, the year after his first mild cardiac event. He had a registered account, a TFSA, the house in Innisfil, and a trust set up specifically for me that he'd been quietly building since I was born. He used the word trust very deliberately. "This is yours, Kelsey," he said. "No matter what happens, it's yours by law." The trust held just over $340,000. I know the exact number because he showed me the statements. I was his daughter. He wanted me to know. In the weeks after the funeral, Sandra was warm and vague. She kept saying things like, "We'll sort everything out," and "Your father would have wanted us to handle this as a family." I was raw with grief, running on 3 hours of sleep and bad coffee, and I wasn't reading the signs the way I should have been. Then my father's lawyer, not Sandra's, but Dad's actual estate lawyer, a woman named Patricia Davies in Barrie, called me directly. She sounded careful, measured, like someone choosing every word with deliberate precision. "Kelsey," she said, "I need you to know that I've received a competing claim against the trust." I stood in my kitchen and felt the floor shift. Sandra had filed a legal challenge. Her position was that the trust had been set up during a period when my father was, in her words, not of sound mind, and that as his surviving spouse, she was the rightful beneficiary. She had supporting documentation, an affidavit from a doctor I'd never heard of, a Dr. Fontaine, who claimed to have assessed my father and found evidence of early cognitive decline, my father who ran 5 kilometers every morning, my father who beat me at crossword puzzles every single Saturday, my father who remembered the name of every teacher I'd ever had from kindergarten through university. I sat down on my kitchen floor because my legs stopped working. Here's what I want you to understand about the next moment. I had 2 choices. I could react, call Sandra, scream, cry, send the kind of email that feels good for 30 seconds and ruins everything for 30 years. Or I could do what I actually know how to do. I opened my laptop. I didn't call Sandra. I didn't post anything. I didn't tell anyone except my closest friend, a woman I've known since university, who immediately said, "Tell me what you need." What I needed was a paper trail. I requested my father's medical records from his GP, his real GP, Dr. Okafor, who he'd seen every 6 months for 15 years. I requested his pharmacy records. I contacted his financial advisor, who confirmed that my father had met with him in person just 4 months before his death, reviewed the trust documentation, and showed no signs of impairment whatsoever. I pulled the original trust documents and had them date-stamped and independently verified. And then I started looking at Dr. Fontaine. This is where my job became the most useful thing I've ever done. Dr. Fontaine's clinic was registered in Ontario, but his billing history with OHIP was sparse. Unusually sparse for someone claiming to do cognitive assessments. His malpractice insurance had lapsed once in 2019 and been reinstated under a different provider. He had 1 complaint filed against him with the College of Physicians and Surgeons of Ontario, which had been closed without further action. But when I looked at his corporate filings, publicly available through the Ontario Business Registry. His numbered company shared a registered address with the property management firm, Sandra's property management firm. I put my pen down. I sat very still for a moment. Then I wrote the number down twice, because I didn't trust myself to have seen it correctly. Dr. Fontaine had a corporate address that matched Sandra's business. I didn't confront her. I want to be very clear about that. I had nothing yet, not legally. I had a suspicious coincidence. In my line of work, suspicious coincidences mean you keep pulling the thread. I pulled the thread. Over the next 8 weeks, I documented everything. I worked early mornings before my actual job started and late at night after it ended. I built a binder, an actual physical binder, organized by tab, because some habits are too ingrained to break, that contained the trust documents, the medical records from Dr. Okafor, the financial advisor's notes, Dr. Fontaine's corporate registration, the shared address, his OHIP billing records, and a timeline I constructed showing that the assessment Sandra submitted as evidence had supposedly taken place on a date when my father was, verifiably, at a Blue Jays game in Toronto with 2 of his old friends from university. I have the ticket stub. I have the photo one of his friends posted on Facebook that evening. My dad grinning with a beer in his hand and a ridiculous foam finger he thought was hilarious. The timestamp on the post is 7:43 p.m. Dr. Fontaine's assessment claimed it was conducted at 6 p.m., the same evening in a clinic 2 hours north of Toronto. I printed the Facebook photo. I put it in the binder behind the tab marked Exhibit F. My father's lawyer had advised me that the formal hearing would go before an Ontario Superior Court judge, a proceeding under the Succession Law Reform Act. Sandra's lawyer was a man named Birch, who had the specific kind of confidence that comes from never having been genuinely surprised in a courtroom. I hired my own lawyer. Her name is Amara, and she's been practicing estate litigation in Ontario for 18 years. When I walked into her office with my binder, she flipped through it for about 20 minutes in silence, and then looked up and said, "Where did you learn to do this?" "I look for fraud for a living," I said. She smiled. "Good. Here's something nobody tells you about court proceedings. The waiting is the hardest part. Not because you don't know what's going to happen, but because you do." I knew what was in that binder. I knew what it meant, and I had to sit on it, quietly, while Sandra's lawyer made his opening remarks, and Sandra sat across from me looking composed and sad, in a way that I recognized from years of watching her stage houses. Everything arranged to tell a story, nothing quite real. She wore my father's favorite color, navy blue. I noticed it immediately, and I chose not to let it mean anything. Sandra's lawyer presented the claim methodically. Sandra had been her husband's primary caregiver in his final years. She had witnessed a decline that she found distressing. She had sought a medical opinion. Dr. R. Fontaine had provided that opinion. The trust, established under conditions of diminished capacity, should rightfully pass to the surviving spouse under the legal provisions of the Succession Law Reform Act. Sandra cried at one point. It was well-timed. The judge, a man in his late 50s with reading glasses that he kept taking off and putting back on when he was thinking, listened to all of it without expression. Then Amara stood up. She walked through the medical records from Dr. Okafor first. No documented cognitive decline. No concerns raised at any appointment in the preceding 3 years. My father had passed a standard cognitive screening as part of a routine physical 18 months before his death with a perfect score. Then she introduced the financial advisor's notes. My father had met with him 4 months before his death to review and reconfirm the trust structure. The advisor's notes specifically recorded that my father demonstrated clear understanding of the purpose and structure of the trust and confirmed his intentions without prompting. Then Amara said, "Your Honor, I'd like to introduce evidence related to Dr. Fontaine's assessment." Birch shifted in his seat. He'd known this was coming. We disclosed everything in advance as required, but knowing it was coming and seeing it laid out are different things. Amara placed the timeline on the record. She walked through it point by point. The date of the alleged assessment. The time noted in Dr. Fontaine's report. The verifiable evidence, ticketing records, a photograph with a geotag and a timestamp that placed my father 140 kilometers away at that same time. The judge took off his glasses. He set them down on the bench in front of him and looked at Dr. Fontaine's affidavit for a long, quiet moment. "Counsel," he said, and his voice had a quality I can only describe as very, very still. "Are you representing to this court that this assessment was conducted in person?" Birch said, "Your Honor, I'd like a brief recess to confer with my client." I'll take that as a yes for the moment, the judge said. He did not sound pleased. We got the recess. Across the room, I watched Sandra and Burge have a conversation that, based on their body language, was not going well for Sandra. She kept shaking her head. He kept his voice very low and very controlled. When we reconvened, Birch withdrew the affidavit. Not the entire claim. Not yet, but the affidavit. Dr. Fontaine's assessment was withdrawn from evidence. What followed was, in legal terms, a fairly swift unwinding. Without the medical claim of cognitive decline, Sandra's case rested on a spousal right argument that didn't hold up against the existing trust structure. A trust, properly constituted and documented under Ontario law, is not subject to the same spousal override provisions as a general estate. My father had known that. His lawyer had known that. That's why he'd set it up that way. The judge ruled in my favor. I don't want to write about what I felt in that moment the way you'd expect. Like relief crashing in, or justice finally served, or whatever phrase makes it feel tidy. What I actually felt was tired. Profoundly, structurally tired, the kind that sits in your bones. And underneath it, something I didn't have a word for right then. Something close to grief all over again because winning meant my father was still gone. The trust was still money left by a dead man, and nothing about any of it brought him back. I called my friend from the parking garage afterward. I sat in my car for probably 40 minutes. She didn't try to make it mean something. She just stayed on the phone. The College of Physicians and Surgeons of Ontario subsequently opened a formal investigation into Dr. Fontaine based on the evidence submitted to the court. I am not able to discuss the outcome of that investigation in detail, but his clinic closed within 6 months of the hearing. Sandra and I have not spoken since. The trust settled into my account in April. I used a portion of it to pay down what remained of my student loans. A very Canadian conclusion, I know. I kept the rest in a TFSA because that's what my father would have done, because he was careful with money in the way people who grew up without it tend to be. I kept the binder. I don't know why. It's sitting in my closet behind my winter coats. Sometimes I think I should shred it. Then I think about my dad at that Blue Jays game with his foam finger in his beer, grinning at someone's phone camera, not knowing that photo would one day matter in a courtroom. I don't shred it. There's something I want to say directly to anyone who's read this far and recognized something in it. If you're sitting in a situation where someone is using your grief against you, and people do, more than most of us want to believe, I want you to know that the most powerful thing I did was nothing. Not nothing, as in giving up. Nothing, as in not reacting. Not tipping my hand. Not letting my hurt become the ammunition they were counting on. I let the numbers tell the story. I let the documents speak. I let the timestamps do the work that no amount of crying or confrontation ever could have done. My father taught me that. Not on purpose. Not with a lesson or a speech. He taught me by being the kind of person who always checked his own work, who kept his receipts, who said things like, trust but verify, with the mild satisfaction of someone who found that genuinely funny. I am his daughter. It turns out that matters more than anything else. I've thought a lot about what Sandra actually believed going into that courtroom. I don't think she thought she'd lose. I think she'd looked at me, grieving, exhausted, a 31-year-old woman standing alone at her father's graveside, and made a calculation. She decided I was the kind of person who falls apart. She decided that if she applied enough pressure in enough official-looking ways, I would eventually just let go. That's the thing about people who operate the way Sandra did. They're not stupid. They're actually quite strategic, but their strategy depends entirely on the other person behaving the way they expect. The moment you stop performing the role they've written for you, the whole plan starts coming apart. I didn't perform grief the way she needed me to. I performed competence instead, and it cost her everything she thought she'd secured. I'm not telling you this to sound impressive. I'm telling you this because I almost didn't do it. There were nights in those 8 weeks where I sat at my kitchen table at midnight staring at a screen full of corporate registry records and seriously thought, about just walking away, about letting her have it, about deciding the money wasn't worth what it was costing me in sleep and sanity and the constant low hum of dread that had taken up residence somewhere behind my sternum. What kept me going wasn't anger. Anger burns too hot and too fast. It's useful for about 48 hours and then it starts burning you instead of anyone else. What kept me going was something quieter. It was the memory of my dad sitting across from me at our kitchen table, walking me through those documents, saying this is yours. Not as a gift. as a statement of fact. He'd spent decades building something for me, carefully, deliberately, the way he did everything. The least I could do was be as careful and deliberate in defending it. There's a version of the story where I called Sandra the day I found out about the claim and said everything I was thinking. There's a version where I sent a long, devastating email at 2 a.m. There's a version where I showed up at her door. None of those versions end with me winning in court. All of them end with Sandra's lawyer using my reaction as evidence that I was, in fact, unstable. She was counting on exactly that, what I've come to understand, not as a lesson I was taught, but as something I lived my way into. Is that integrity under pressure is the only kind that actually counts. Anyone can be principled when things are fine. The question is who you are when someone is actively trying to take something from you and they're doing it with a smile and a forged medical document. Dr. Fontaine signed his name to something that wasn't true. Sandra built a legal strategy around a lie, and the lie worked perfectly, right up until it met a timestamp on a Facebook photo and a ticket stub from a Blue Jays game. That's not luck. That's consequence. Actions accumulate. Choices compound. What you do quietly, when you think no one's watching, has a way of showing up later in rooms you didn't expect. My dad knew that. He lived that way his whole life. And in the end, even after he was gone, the care he'd taken, the records he'd kept, the lawyer he'd chosen, the way he'd structured everything properly, it all held. His integrity outlasted him. It showed up in that courtroom, and it did its job. I keep his foam finger in the closet now, next to the binder. Some days that makes me smile. Most days, it just makes me miss him. But I'm glad I fought for it. I'm glad I was his daughter in the way that actually mattered. Not just in name, but in how I handled myself when it was hard. That's the only inheritance that doesn't fit in the trust account, and nobody can file a competing claim against it.